Hello, everybody. We're just going to give everyone an extra minute just to join the Zoom call, and then we'll start in about 1 minute. Okay, well, let's get started. Hello, everybody. My name is Michelle Kinney. I am a family and fertility lawyer in both BC and Nunavut. I'm here on behalf of the Law Society, and I note Santana is also here, Santana and I work together on a project in Nunavut around family violence, and Santana is here to help us navigate all the tech sides, so we're thankful for that. I'm also here with Catherine Shadbolt, and we will be today talking about what happened in family law in 2025. Just to introduce Catherine a little bit, Catherine has practiced in family law for almost 40 years and is a wealth of information. She is out of Ontario, Ottawa, I believe. Is that right, Catherine? You live in Ottawa?
Sorry.
And since 2023, she's been a sole family law practitioner. She does mediation, mentoring, teaching, legal opinions, serves on various executives around dispute resolution and family law sections of the Ontario Bar Association and the Canadian Bar Association. And she has been recognized in the 2026 edition of the Best Lawyers in Canada for Family Law. And she has received this distinction for the last 14 years. So we're really grateful to have Catherine here today with all your experience. And I think this will be a
Nice to
really
be here.
helpful conversation. Thank you. That's great. Also, Catherine and I are both mediators with the Family Law Mediation Program in the Northwest Territories. So, um, okay, so we're going to today talk about the key cases, the resources, and what happened in 2025 in family law. So this presentation looks at what actually happened. What did 2025 actually do to Canadian family law? Not just what changed on paper, but how the courts are deciding cases and what that means for us as family lawyers in our day-to-day practice. The real unifying themes this year were things like a deeper commitment to child-centered and trauma-informed analysis in family law, judicial skepticism of formalistic tests that ignored power imbalances. There was continued pressure to resolve disputes earlier and outside of court in family law cases. And there was some incremental but important refinements around sort of the bread and butter issues around parenting, support, and property. Next slide. If we zoom out, 2025 was not about significant legislative overhaul, although we have seen some movement in that direction as well. So some of that has been in the Northwest Territories. It's not yet enforced, but there was a bill to amend the family laws in the Northwest Territories, generally to align those with the Divorce Act changes from 2021. It would change the terminology to things like parenting time, decision-making responsibility, contact for non-parents. It describes new duties for parents, legal advisors, and the courts to encourage and inform the use of dispute resolution in family law cases and to update gender-neutral pronouns and terms. There was also a new act that received royal assent in the Yukon. It's also not yet enforced, but should be probably this year, the Inclusive Yukon Families Act. And this was around families that are created by assisted reproduction to ensure that all diverse family structures have recognition. So that's a law that will provide for greater clarity when families are formed through things like surrogacy, uh, sperm donation, egg donation, and embryo donation, making it clear who are parents in that scenario. And then there's the in BC, there's the BC Family Law Act Modernization Project. So also it's had not created legislative change yet, but it's been a multi-year um, uh, process with consultations to look at the BC Family Law Act and make changes across the board. Next slide. There was also an update to the federal child support tables. So effective October 1st, 2025, there is an adjustment to the federal child support tables, um, and which makes a bit of a change. They hadn't been updated, I think, in at least, I think, 10 years. So just to note that there is new tables, and those are what you should look to assess child support going forward. Next slide. The big themes, though, for 2025 were about how evolving legal frameworks have changed and how the courts are applying existing law. So, really, three big patterns emerged this year in 2025. The first was that context matters, especially where there's migration, families moving between jurisdictions, family violence, or where there's unequal bargaining power. This year, the court showed us that they are less willing to accept surface level narratives about consent or shared intention and more about looking behind to what the context is and why people are making their choices and decisions. Second, there is an unmistakable shift away from adversarial escalation, and this has been led by BC, but we're seeing it all across Canada. In BC, they're creating schemes within the courts to move families out of court and adversarial escalation. Courts and governments across the country are trying to find ways to keep families out of full litigation unless absolutely necessary. And this is a trend we're seeing everywhere. Third, family violence continues to shape legal doctrine, not only in parenting, but in jurisdiction issues, in remedies available, and in civil liability. We're watching the legal system struggle, sometimes awkwardly, to respond to coercive controlling violence and to deal with the true impacts of family violence. Next slide. So to start, we're going to talk about what has happened in the Supreme Court of Canada. There's a couple really key family law cases. First is the Ahluwalia case, and this case really sits at the intersection of family law and tort law, but its implications extend far beyond civil damages. And Catherine just told me before we got on this call that there's rumors that this decision is coming down soon. So trial was, I think, at the beginning of 2025, and we've been awaiting the decision, and apparently it's almost here. So we don't have the decision on this case, but it will change the landscape for family law. At trial, the judge recognized a new tort of family violence to capture the cumulative harm, of course, of controlling violence. So something traditional torts have struggled to address. So attaching civil liability in family violence cases. The Ontario Court of Appeal reversed that tort and decided that the existing torts were sufficient and that creating a new tort was unnecessary and potentially disruptive. So then it was appealed to the Supreme Court of Canada. And so the Supreme Court of Canada is grappling with the fundamental question is, can the law meaningfully address patterned cumulative abuse using the tools designed for discrete incidents? This decision, or should we have a new tort of family violence that can be used alongside the other remedies that already exist in the family law? Can we have a civil remedy as well? So this will really impact family law with respect to how courts conceptualize coercive controlling violence, how damages and remedies are framed, how settlement leverages shift in high conflict cases. And if the Supreme Court of Canada recognizes the limits of existing torts, we may see pressure for new remedial frameworks, whether judicial or legislative. So, um, broadly, this case reflects one of the key 2025 themes, and the law is still catching up to the lived experiences of family violence. So, looking forward to having this decision come down and see how that all unfolds. The other big Supreme Court of Canada case is the Dunmore case. And this is arguably the most important family law decision of 2025. It's a landmark decision that emphasizes a trauma-informed, child-centered approach for determining jurisdiction in parenting disputes, especially concerning domestic violence survivors. So again, the bringing the key themes, we're seeing a real theme around how the courts deal with domestic violence and a more contextualized, trauma-informed approach to making decisions. This case this case involved a transnational family. The mother was an Iranian citizen and a permanent resident of Canada. The father was a Canadian citizen and had lived in various countries due to employment. Their child was born in Ontario in 2020. And after a brief return to Oman in early 2021, the family came back to Ontario and then the parents separated after an incident of alleged domestic violence. The father moved to Oman and initiated custody proceedings for the child there. The mother remained in Ontario with the child and commenced proceedings in Ontario. The father challenged the jurisdiction of the Ontario courts and argued that the child was habitually resident in Oman and that Ontario lacked authority to make parenting orders about the child. The motion judge and the Ontario Court of Appeal both disagreed and found that the child was habitually resident in Ontario. The father appealed to Supreme Court of Canada. And the Supreme Court of Canada um, adopted a flexible, child-centered approach to habitual residence. The court explicitly rejected the shared parental intention test of where the family had intended to be, acknowledging that there was a vulnerability to manipulation in cases of family violence, and stated that it had wrongly takes the focus away from the objective factors, such as where a child lives, and gave undue priority to a parent's subjective views. Crucially, the court recognized the role of coercive control and abuse in shaping family dynamics and legal outcomes, stating, and this is a quote, evidence of emotional, psychological, or verbal abuse, intimidation tactics, and other forms of controlling behavior by one party that cause fear in the mind of the other party may provide a foundation for the type of duress which could serve to vitiate consent. Well, it's not directly relevant in the same way to the question of where the child resided, it forms part of the broader context of which judges should always be mindful. And this matters because this decision ensures that courts need to consider the full social context, including gender dynamics, migration, and abuse, when determining things with respect to parenting cases, in this case, jurisdiction. So by affirming the jurisdiction of Ontario courts to preside over these transnational cases, particularly where there's coercive controlling violent or gender-based violence, this decision protects survivors from being forced to litigate in jurisdictions where they might face danger, discrimination, or systemic barriers. So the court's approach really reinforces Canada's commitment to best interest of the child approach as a paramount consideration in parenting decisions. And beyond its trauma-informed approach to the habitual residence test, the court acknowledged the obstacles survivors face in family law proceedings, and this should serve as a template for comprehensive, contextualized legal analysis in cases involving safety of women and children. For practitioners, Dunmore changes how we have to consider things like jurisdiction. And I would argue that this is a case that could have much further reach than just jurisdiction. I could see this playing out in things like relocation cases as well, which also hinges on jurisdiction and best interest of the child. And these are live issues that often occur in Nunavut, where there is a lot of migration and moving to and from Nunavut from the south and elsewhere. So now I'm going to turn it over to Catherine to talk through what has happened in Ontario, which I mean, Ontario is the hub of family law, really, in Canada, and we all look toward Ontario's case law and the themes that come out of Ontario, and a lot has happened there. So over to you, Catherine. Thank you.
Thank you, Michelle. And I'm really happy to chat with you today. And I look forward to your questions as well. So, no year in review would be complete without looking at the AFCCO Parenting Guide and Parenting Plan template. These are really, really important resources in Ontario. And I think there's 5 key questions, which I'll try to answer today. Number 1, what is the parenting guide and template? Number 2, how did it come about? Number 3, does it have credibility? How have our courts responded to it? And number 4, how useful is it for us as family law lawyers across Canada and mediators? And then I'll give you a practical example of how it works using a 4-year-old and a 7-year-old. I'm
So
not sure
just
if you have.
yeah, just to interrupt, everyone, you should be able to access these online. I think Santana had posted them so that everyone has these or should have them already, and you can access them if needed.
Perfect. Okay. So assuming you have them, if not, I'll recirculate them. It's a 2-part document. So you have the parenting guide, which provides really useful information about the stages of development of children from infants to age 18, children who are impacted by separation or divorce. And as well, it sets out in the guide some of the most common issues that separated parents have to address, like social media, communication for their children who are at different stages. And then, second, to accompany the guide, you have a parenting plan template, which is super useful because it has very detailed clauses, optional clauses in plain language for parents to consider for their parenting plans. And the clauses cover a broad range of issues: the regular weekly schedule, the holiday schedule, religious celebrations or honor days. Another section sets out how to deal with social media and for children in 2 different homes, how information is shared between parents, and what future reviews may look like as the children age and the parents want to revisit the status quo. The main goal of the parenting guide and template is to put the interests of the children first. So it's no longer about parental rights, who has custody, who has access, and we know that language is gone from the amendments of the Divorce Act in 2021. The goal is to focus in on the developmental stage of children and what a parenting plan may look like. The goal is not to eliminate lawyers. Lawyers are extremely useful, and that's threaded throughout the guide. But it's, as I said, written in such a way that you don't have to have legal expertise to use this as a very important resource. And therefore, parents can use it, they can consider it, and then they can bring it to their lawyer perhaps later after they've considered it for the lawyer to execute the complete parenting plan. So, how did it come about? Well, in 2018, there was a family law conference in Ontario, and a family law lawyer addressed the conference participants and said, isn't it a shame we don't have a resource, we don't have a precedent that's really, really thorough and that's focused on the interests of children? All too often, I go to negotiations, and the other lawyers are really talking about what their father or their mother, what their clients want. So, in other words, about parental rights, but they're not really focusing in on the children. So, the AFCC Ontario chapter created a task force that consisted of 6 lawyers and 4 mental health professionals across Ontario that represented our geographical and racial diversity. Professor Nicholas Balla from Queen's University in Kingston, he started drafting the clauses that you'll see in your templates. And then in later stages, he asked the judiciary to weigh in, and he also consulted with materials that Department of Justice was producing. So what you have are the template and the guide in your hands today. You have version 2, which was the version that came out after the amendments to the Divorce Act in 2021 to take away the language from the previous version that came out in 2020 that talked about custody and access. So now everything's consistent with the amendments to Divorce Act to talk about parenting plans, decision making, and the like. Does the AFCCO parenting guide and parenting plan template have credibility in Ontario with our courts? Well, I can say definitively that since the 2021 amendments to the Divorce Act, absolutely, our courts are embracing it. So next slide, please, Santana. We have a case that is called DuPont Good versus Ashmead. It's actually 2024 that we're still talking about, where the presiding justice accepted the parenting plan guide as independent and objective evidence of what was in the best interest of two children, ages 5 and 7. Now, His Honor noted that in this case, the only evidence came from the parties or the parents. There was no independent and objective evidence from the Ontario Children's Lawyer, from a parenting assessor. There was no other expert evidence. So His Honor said, in the absence of such evidence, I refer to the parenting plan guide as independent and objective evidence of what is best for children. And he described, His Honor described the guide as saying it summarizes basic social science knowledge about the effects of parental separation on children, provides suggestions and guidance to help improve communications and cooperation, and offers valuable guidance about formulating parenting arrangements that meet the needs of children. What was the response to that decision? Well, there was a backlash from Ontario lawyers. Very senior, respected family law lawyers said, wait a minute, this judge has gone too far, because what he's done is tantamount to taking judicial notice of the guide. And one senior lawyer said, you can't take judicial notice of social science literature. You can only take judicial notice of facts that are so notorious or accepted, either generally or within a particular community, as not to be the subject of dispute among reasonable persons. And this guide is not that body of facts. Or, he said, the court can take judicial notice of facts that are capable of immediate and accurate demonstration by resorting to readily accessible sources of indisputable accuracy. But again, this isn't that material. So other lawyers have said quite simply, the court should be directed to look at the specific individual best interests of a child in the case at bar before them. And the fear or the concern is with this guide and template, the court will use that simply to rubber stamp a decision about parenting. So that's where we are today. Having said that, the debate continues, the discussion continues, but we still have judges endorsing the guide. Next slide, please. So in the case of Dupuis and Dupuis, 2024 decision, the presiding judge combined information from the guide with the evidence tendered in her decision, in Her Honor's decision, noting that the guide supports the fact that younger children benefit from having a home base and consistency in their routines. Her Honor was dealing with a very young child in this case, and therefore, based on the evidence plus the guide, Her Honor decided the best parenting schedule was one where there was a primary parent. The other really discussed case has just come out, 2025 decision of Tremblay-Chartier versus Blanchette, and it was appeal of an interim parenting order to the divisional court. and the divisional court dismissed the motion judge's parenting order. The motion judge was dealing with a 15-month-old child. The status quo had been the child was primarily with his mother, and the father asked at the motion for equal parenting time. And among other reasons, the divisional court found that the motion judge had not given reasons to depart from the recommendations in the AFCC parenting guide because Her Honor agreed with the father that there should be equal parenting time and imposed that schedule within a 6-week period. So Her Honor said the parenting guide exists, but it's not binding on this court. And the divisional court said, no, you have to go further in your reasons and really grapple with what that guide is saying and why you didn't apply what they recommend, what the guide recommends in the particular case. The other really interesting factor about this case, as Michelle was speaking about family violence, I'm finding the courts in Ontario are extremely sensitive about family violence now. They're extremely sensitive is the word, but also really paying close attention to it in their decisions. In this particular case, the mother had alleged there was family violence throughout the relationship. She had gone to the police several times and reported what she had experienced. The police reports didn't really make a recommendation that the father be charged, and they were sort of left. They weren't saying conclusively that family violence occurred. And so the motions judge in this case noted that the mother had made allegations of family violence, but Her Honor said the investigative police reports came to naught, and therefore the violence didn't occur, and therefore an equal parenting time is appropriate, and there's no reason why these parents can't communicate frequently, which is what, of course, has to happen when you have an equal parenting regime because of the ongoing interaction with children and parents. Now, the divisional court did not like that at all. So they said that just because police reports don't make a finding or don't make a recommendation that the other parent be charged, you cannot conclude that there was not domestic violence, especially in the interim. And secondly, at the very least, you'd have to grapple with the fact that there was very high conflict, and therefore an equal parenting regime and one that might invite joint decision making is not appropriate. So next question I asked at the outset, how useful is the guide and template among family law lawyers and mediators? It's extremely useful. We're using them all the time in our negotiations. As a mediator, I hand them out as a resource. I might have several resources to hand out to people, but it's really helpful. For example, if there's you have a client or there's another party who's saying, in the case of a young child, to use the examples in these cases, I want equal parenting time, you can present as a neutral this resource to say, well, when you look at the developmental stages of children, there is a body of information that says maybe not at this stage. As children get older, perhaps it can be introduced depending on the circumstances. So they are being widely used despite some of the backlash, as I was saying, that existed earlier. Now, of course, in cases where there is family violence, it may not be appropriate to impose the terms of the guide. Sometimes collaboration and cooperation between parents is not possible, so we have to be alive to those issues. And of course, in family violence situations, voluntary agreements may not be appropriate. So before I turn to this next topic, non-disparagement clauses and parenting plans, I just wanted to leave you with one of the practical examples of how you might use the guide and template. If you were dealing with a 4-year-old preschooler, for example, you'd go to pages 20 and 21 of the guide, and there's a general statement of the needs of preschoolers and what's particular to their stage of development. Then you'd go to the template, pages 9, 10, and 11, and you'd see different options and clauses and terms that you could consider putting into a parenting plan, or your clients would consider putting into a parenting plan. To take another example of a 7-year-old, on page 23 of the guide, it goes into more detail about what a child of that age might need. The child would have more developed coping skills, have exposure to relationships outside their home, from schools, activities, art, and music. So both parents having significant involvement in that child's life would be most probably, in many cases, appropriate. So then you'd go to the template and see what the examples are, what the options are for specific parenting schedules. And once you have the parenting schedules in place, you can start building the rest of the clauses for a parenting plan. Now, while we're on the subject of parenting, we've seen a number of cases in 2025 with non-disparagement clauses, as you can see in the slide before you. And what really struck me when I read these cases is just how broad those clauses are. So you take the first one where Her Honor said it's neither parent shall denigrate or be critical of the other parent, either overtly or covertly, but in any communication with the children or with others when the children are nearby. And lastly, the parent shall advise others to maintain the same standard and to refrain from criticizing the other parent in front of children. I included the case of RL versus VM 2025 case, because His Honor in that case said neither parent is to disparage, slander, or speak negatively about the other parent on social media, very important these days, or in the presence of the child, and again, reference to others, nor allow others to do so. Next slide, please. We had a very interesting case in 2025 where a judge found a really good solution to protecting children's privacy in the case law, and yet balancing the open court principle. So as you know, often what we do if we want to protect children's privacy is we apply to have their names initialized. In this particular case, Justice Masden anonymized the case by using an online random last name generator for the title of proceedings. So it's Kirby and Woods, but that's not the real name of the parents. And then throughout the case, Her Honor used parent 1, parent 2, initialized the children's names. And so I think we'll be seeing more of this where children's privacy is protected, and yet we still have the case memorialized for purposes of precedent. Next slide, please. So moving on to child support, imputing income is one of the main issues we see in Ontario courts. As a general rule, as you know, separated parents have an obligation to financially support their children. They can't avoid that by a self-induced reduction of income. And so the court will impute income as one method to make sure that the parties are assuming their obligation towards their children, and that they are earning what they're capable of earning, or their income is imputed so that they have the same income as what they could be earning. Our leading case is Dragali and Polly, 2002 decision, but it's referred to in all the cases throughout. Mr. Polly was a tool and die maker during the relationship, during the marriage. He earned $31,000 per annum. 2 years after separation, he decided he'd go to university, take courses. He wanted to be a teacher. And his argument was, my income will increase beyond the $31,000 I earned during the marriage, and I'll be able to pay child support in a higher amount. But of course, while he was going to school, he wasn't paying any child support. The mother applied to the court for imputation of income to him even while he was going to school, and the trial judge imputed $31,000 to him, saying school was just his choice. went to the Court of Appeal, and the Court of Appeal said the father's decision to go to university to upgrade himself to become a teacher was reasonable. And so they adopted his plan to become a teacher, but they still imputed income to him, not of 31,000, but of 16,000, because they said that was an amount he could earn outside of his school classes. So he could go to school, take various classes, finish his degree, but he's still capable of earning 16,000, and they ordered him to pay child support while he was in school. Next slide, please. So in keeping with Michelle's themes that were so well set out, again, family violence and how the court is treating family violence is becoming increasingly important and nuanced. In the case of Coley and Tom, the court found that the mother had been subjected to significant physical and emotional violence throughout the parties' relationship. She was not working at the time of separation and had the care of the party's young child. Still, the trial judge said she could work minimum wage and imputed income to her of 31,000. This was for spousal support purposes. On appeal, the Court of Appeal reversed that decision and declined to impute any income and stated that the trial judge thought that the emotional and psychological consequences of the family violence did not affect the mother's ability to work full-time at a minimum wage. But the judge's error was that he failed to engage that possibility was there and was real in any way in his reasons. So I think we're going to see more understanding of the impact of family violence in cases to come. And I'm expecting we're going to see more and more expert evidence to show the connection between what happened during the marriage where there was physical or emotional violence and a party's ability to work. Next slide, please. So in getting back to the child support issues, in terms of imputing income, we seem to have a lot of cases dealing with RSP income and whether it should be excluded for the purposes of determining child support. As we know, it's presumptively part of total income in a party's T1 return, so it should be included. The federal child support guidelines includes RSP withdrawals. However, in a 2025 case, one of our specialized family law judges said, if the RSP withdrawals are fairly regular and appear to have been used to cover ordinary living expenses for the party's lifestyle choices, so they're being drawn on almost as a form of income, then they are more likely to be included as income. But you have to look at the reason for the RSP withdrawal. So two exceptions that may justify excluding RSP withdrawals from income for child support purposes are if the RSP withdrawals were used to pay legal fees. Let's say someone's in an action to get child support, they have to pay their lawyer, they withdraw RSPs. There's no reason why their income should be inflated by that RSP withdrawal. The legal fees or a specified debt had to be paid. It doesn't really have anything to do with supporting an ongoing lifestyle. And number two, the use of RSP withdrawals to make ends meet when a party is not receiving support. Obviously, they need to support the child or children somehow, and having the RSP money is a necessity and therefore should be excluded from being imputed back to their total income. Next slide, please. So I wanted to include one other case for you in terms of Section 7 expenses, because this 2024 case is a very interesting one, and I think we'll see this type of decision more often, especially with increased costs. So in this particular case, there were 4 children who were heavily involved in extracurricular activities while the parties were still together. Post-separation, the father continued the children in the activities. And for 3 years, post-separation, while he continued them in the activities, the costs weren't that high, $5,700 to $8,000. So Justice Audette found the mother was required to pay her proportionate share of the children's activities for those 3 years. However, after the 3 years post-separation occurred, the father, without notifying the mother or consulting with her, enrolled one of the children in a much more expensive dance program. That cost alone shot up to $14,444 in 2023. Her Honor found that these increased costs post-separation were not necessary or reasonable. So next slide, please. So last, I'll leave you with a property case, Lang-Newlands versus Lang-Newlands. It went to trial for 30 days in 2024, and it's been recently appealed and was heard by our appellate court on January 13, 2026. It deals with discretionary trusts. So we're all waiting to get some clarity on how discretionary trusts should be dealt with. Should they be excluded from net family property or included on a very high level? The wife's father was a very successful business person. He had multiple businesses. And during the wife's marriage in 1993, he gifted her shares in a company known as SHL. And he signed a document, it's called the 1993 agreement, at the same time saying it was his preference that upon his death, those shares would be passed from the wife to her 4 children, his grandchildren. And so the business basically would be passed on intergenerationally throughout the families. Later on, about 10 years later, the father, senior business person, had a cancer scare and he rethought his estate planning and thought, I better go back to those shares and make sure that not only the value is excluded from net family property, but the growth in value. So he created a trust. And to enable the value and its growth to be protected, the wife had to transfer into the trust her SHL shares from 1993. And so after that happens, there is a separation, and the issue becomes, does that trust that gets set up, is that value excluded property? And the husband argued on appeal, no, because for it to be a gift under the Family Law Act of Ontario, the wife would have had to receive it by a third party, but instead she did the gifting. She gave her SHL shares to the trust, to the father, and by that action, it's no longer a gift and it's property. And the wife's counsel argued, no, 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 no. You have to look at the whole intention. You have to look at the totality. The father senior was doing estate planning in 1993. That was transaction number one. Transaction number two happens years later, but it's all part of the same intention for the father senior to do estate planning and exclude his business interest by passing it on to the wife and then his grandchildren. So we'll see what the outcome is there. Thank you.
Thank you, Catherine. That's a lot has happened. A lot has happened in Ontario. I particularly just think like the AFCC parenting plan and parenting guide is just such a helpful, useful resource for all family law practitioners across Canada. So thank you for sharing that. Um, we're going to finish with some of the other cases that have happened across Canada with respect to trends on family law. So we're going to start with a case out of the Northwest Territories. Next slide. And this was a case that contemplated the meaning of spouse in the Northwest Territories. And so the Northwest Territories family law legislation is very similar to Nunavut's. So this is informative for Nunavut. And this was an estate law case, but it relied on family law jurisprudence out of Ontario. So it will impact the family law interpretation. And this case really grappled with, can a couple be spouses under the law without actually ever living under the same roof. And Northwest Territories and Nunavut define spouses as including people who have lived together in a conjugal relationship outside of marriage if they have done so for at least a period of 2 years. So in this case, the judge drew on Ontario's case law and held that the spousal status turned on the totality of the relationship. You can't just use a checklist or say it's one particular factor. You have to look at all of the context of the relationship. And they said that a rigid adherence to legislative cohabitation requires could give way to decades of shared life, finances, public commitments, to which bear the hallmarks of a marriage-like union. So the message here is that the courts may look beyond formal living arrangements to give effect to the reality of the relationship. And the other thing about this case that's I think important is it shows why, as lawyers in Nunavut, it's important to know what the leading case law is across Canada, because when you're in a jurisdiction that does not have a flushed out body of case law like Nunavut and Northwest Territories, you need to look outside of the territories to find case law that will support your position. And so the judge did that in this case. Next. In BC, there was a 2025 case that really complemented the Dunmore case. So the Dunmore case was one of the Supreme Court of Canada cases that we talked about jurisdiction and migration. So this case really put Dunmore into practice, and it was a situation where the parties faced a very real concern of having their matters split between Italy and British Columbia, so which would lead to multiple proceedings and conflicting decisions, possibly in two different jurisdictions. And again, this is a situation that I think often arises in Nunavut, where one person might move, and so you have two jurisdictions that could make decisions around things. And how do you grapple with that jurisdictional challenge? So, what was striking in the BC case was not a new legal test, but an assessment of the practical consequences. What happens when you have duplication of costs, inconsistent orders, and a strain on families? So this case really underscored that jurisdiction fights are not abstract. Delay and indecision can result in fragmented litigation that is difficult and sometimes impossible to unwind. And this case attracted international attention and has been looked to because I feel like this is a growing issue in our world where families are made where people are more migratory. People do move a lot. So the real takeaway here, as I see it, was that Nunavut has significant migration to and from the territory, and so to be paying attention to the jurisdictional issues. Next. A BC Court of Appeal case with respect to property, and that it was as always, property law continues to generate litigation, and Mills really tackled one of the hardest issues is tracing excluded property from asset to asset. And here the court acknowledged the conceptual difficulty that, excluded property may lose its character through commingling, reinvestment, conversion. How do you trace people's excluded property when you're dealing with property issues? So Mills did not create a bright line rule, but it did push toward a clearer reasoning and based on evidence. And practically, it really enforces for the role of lawyers the need to really look at financial report records, expert evidence, and to provide your clients with early advice about risks of commingling and how to keep things, if people want to be keeping things separate, how you do that, and to be clear about that. Next. Another Court of Appeal, BC Court of Appeal case, and it addressed the expanding role of parenting coordinators, and that is kind of a distinct issue. But the reason I thought this one was important was because it provided a really clear message around dispute resolution options, saying that, alternate ADR professionals are valuable, but they cannot displace statutory responsibilities or judicial oversight. And it really reinforced the need for careful drafting in orders and agreements um, around alternative dispute resolution and having other professionals involved. So the takeaway here is if you're acting as a dispute resolution professional, and I would say it goes beyond parenting coordinators to mediators, arbitrators, or parenting coordinators, make sure that your authority to act is clear and that all the parties are clear about what that line is and what you are doing. Next. In BC, one of the most practical developments across Canada, I would say in 2025 was the expansion of BC's early resolution model. And I really think that that provinces and territories should be looking to BC and what they're doing in this regard in provincial court, particularly around things like parenting, is now, as of November 1st, there's more registries across BC that require parties who are going into provincial court, which deals here with, parenting, child support, spousal support, but not property, that the families have to do a needs assessment about what does that family need and what options would be helpful for them. They have to attend information sessions and get referrals to legal and non-legal services to help meet those needs. And they have to attempt at least one consensual dispute resolution. And those are also built into the court process where you have to do a mandatory family case conference after the assessment and after the information sessions. And early data from Surrey and Victoria, which have had the early resolution program for a while, have suggested that with the help of these kind of early interventions that keep people out of immediately going to the courtroom, that families have been able to resolve without even filing. And there's been a 60% success rate of fewer cases having to actually go to court. So this is not just procedural tinkering. This is part of a cultural shift toward front-end problem solving in family law cases to keep families out of court. And so the takeaway here, I think, is that it's a real testament to early dispute resolution and interventions, that they can truly help families. And as lawyers, we can facilitate families, doing more dispute resolution and trying to solve problems before ever having to, file a court application, for example. Next. BC also updated their pick list, where we call them, for provincial court family cases. So I have included links here because I just think, like the AFCC Parenting Guide, I think this is a really practical resource for family lawyers. And sure, it's out of BC, but it has a whole list of drafting terms for if you're making agreements or orders. So like if you need to be like, how would I word that particular clause? I know I want to say XYZ. There's a whole pick list that you can use out of BC to find wording for terms. So they have ones for family law and parenting cases, but also for child protection cases. So the links are there, and I just think this is a really useful tool for lawyers even outside of BC. Next. To finish, just some takeaways that really 2025 reinforced that context is critical, especially where children, family violence, and migration intersect. And this is a key issue in Nunavut. Courts are increasingly skeptical of rigid tests that ignore lived realities. Procedure matters. Early resolution models are shaping how and whether cases reach court across Canada. And while the fundamentals of family law have remained stable, the way that they have been being applied continues to evolve. So if you look at how the law is unfolding across Canada and lean into those interpretations and drafting and advisory strategies to these trends, I think that it puts you in a well-positioned place as the family law continues to evolve in Nunavut as well. And I think that is the last slide. Next, yeah, questions. So if there's any questions, I know we don't have a ton of time, but I'm also happy to stay for a little bit longer if people need to leave. Um, but we're happy to take some questions if anybody has any questions. Is there any in the chats, Santana?
No.
Okay. All right. Well, I don't see anyone's hands up. So seeing none, thank you, Catherine, so much for being here. Really, really appreciate your expertise and insight. And thank you to Santana for keeping us all teched up. And thank you to all of you for attending. And I hope you all have an amazing rest of your day.
Thanks, everyone. Thanks, Michelle. Thanks, Santana.